Good morning. Probate court number 2 is now in session. Judge Pamela Medina presiding.
Morning, everyone.
Good morning, Your Honor.
Good morning. I call cause number 486751-401. Mr. Nikoboff, Boronda, and Greenlee. Are you present? Ready to proceed?
Yes, Your Honor.
Mr. Greenlee's here, Your Honor.
Yes, Your Honor.
And Jorge Bruin is present as well, Judge.
Thank you.
And Your Honor, if I may introduce myself, I'm Sam Palermo here for Fleming Law on the motion for reconsideration set this morning also.
Okay.
In Your
Oh,
Honor,
I see it. I see it. Thank you. Okay.
I'm sorry, Your Honor, Lewis did a counsel for Natalie Fleming in her capacity as independent executor of the estate of Michael Fleming.
All right, Mr. Detta, thank you. All right, we have traditional no evidence motion for summary judgment to defendant Audrey T. Manito.
Yes, Your Honor, that's my motion. I'm Scott Greenlee.
All right.
Okay, are you ready, Your Honor?
Yes, I am. Thank you.
Okay, so we've got two motions on file, and one of them's for Natalie Fleming individually, and the other's for Audrey Manito. The motions are similar. They're no evidence. They're hybrid motions. It's a no evidence motion, and it's also a traditional motion for summary judgment. And so the no evidence part, the argument is after adequate time for discovery, there's no evidence to support any cause of action against Natalie Fleming or Audrey Manito. And clearly there's been an adequate time for discovery. I think this is the third time the discovery period's been closed, and there was also the expert deadlines have been opened and closed, and now we're about 30 days before trial. And it's in the sense that it's a traditional motion, we've also attached deposition testimony in support of our arguments, and we've attached opinions from experts that that everything Natalie did to wind down the estate and an insolvent law firm was reasonable and necessary, and similarly for Audrey Manito, I think the only allegation against her is that she drafted a letter to clients. She was an employee of the law firm, and that was reasonable and comported with the state bar rules. I'll give you a little background information first, Your Honor. The decedent in this case, Michael P. Fleming, was the sole managing partner of a law firm called Michael P. Fleming and Associates PC. It's referred to in the briefing as MPFA. You probably saw that quite a few times if you read everything.
Yes.
Mr. Fleming died unexpectedly back on July 1st, 2020. Less than a month before he died, his law firm, MPFA, took out a $500,000 loan for operating expenses from Veritex Bank. And importantly, and I don't think this is disputed at all, the entire proceeds of the loan were transferred to Jeremy Raddick's checking account. It didn't go to firm operating expenses. It didn't go to any of the employees of the firm. About a month later, in August, there wasn't any money to make payroll for the firm or to fund expenses. And if the court accepts Mr. Raddick's factual allegations in this case as if they're true, this money was used to repay him for loans he made to the firm. He alleges he provided office space in a building that he owns. He paid off debts of the firm. advanced payroll, personally guaranteed the loan to Veritex. But importantly, none of this has anything to do with Audrey Manito or Natalie Fleming. We've personally, I've wondered for 2 years why Mr. Raddick sued employees of the law firm. There's been special exceptions on this back in May of 2022. We're on the 4th amended petition. It's still not clear what allegations are. They sort of vaguely allege improper conduct or unlawful conduct by Natalie or Audrey, but if the court reads the allegations that they've been made by them carefully, it's all alleged promises made by the decedent, and the court's probably aware of the procedural history by now, but way back, the defendants were granted summary judgment on Mr. Raddick's breach of contract claims. As part of that motion, the defendants argued, and the court granted the motion that Mr. Raddick's not entitled to any attorney's fees on individual cases. There was no consent from the clients for him to share in fees. There was no, he readily admits he didn't have joint responsibility for any cases. His deposition was taken. He confirmed he had no agreements with Natalie or Fleming or Audrey Manito. He confirmed there's no evidence Natalie or Audrey received any money from him to support a claim for unjust enrichment. No promises made by either of these defendants to support a claim for promissory estoppel. Natalie testified in her deposition that's attached to our motion that she had no knowledge of the dealings between her husband and Mr. Raddick until after her husband died. Audrey's deposition was taken recently. She had no knowledge of anything other than that Mr. Raddick had loaned the firm some money, but she had no knowledge of any kind of agreement between them or any dealings, or wasn't a part of that. She was just sort of a workhorse at the firm who worked up the cases as she was told. So here we are. There's no evidence of any misrepresentations or promises. The defendants have retained well-qualified experts to give opinions in this case. Professor Lynn Baker has dedicated her entire career to issues of attorney ethics. She's a professor at UT. She works across the country on complex settlements, helping courts approve those and make sure there's no improper conflicts of interest. We've also attached opinions from Robert Stanfield, who the court probably is aware of him. He's a prominent, probate lawyer in Harris County. And importantly, Your Honor, a similar motion to this was filed back in September, and it was a little bit bigger bite. At that time, we were trying to get summary judgment for all the defendants. This time, we're just here on Natalie and Audrey. But back at that time, the defendants argued, unfair surprise, and argued about they needed more time for discovery. They needed more time to retain competing experts, and Judge Newman granted their request. They were given a 5-month extension to conduct discovery, to obtain competent summary judgment evidence from experts of their own. And here we are 5 months later, and they've taken one additional deposition, I believe, and that was the one of Audrey. They don't attach it because she didn't say anything that helped them, quite honestly. So it's it's our position, we're a month before trial and there's no evidence to support these claims that are left after the summary judgment of promissory estoppel, unjust enrichment, fraudulent transfer. No evidence that Natalie or Audrey were responsible on this promissory note to the bank. So we would ask the court to grant summary judgment, and I'll stop there, Your Honor, unless you have questions for me.
No, thank you. Mr. Barunda? Or Nicomoff?
Mr. Barunda, you're on mute.
Well, that was a rookie mistake. My apologies, everyone. Your Honor, I'll take a first crack at giving the court some broad strokes background on this case, because some of the claims are equitable, and so I think the equities are important. Mr. Nicomoff can then speak more specifically to the issues discussed in the motions, but I think it's important. Somewhere along the way, the defendants have tried to frame a narrative that Mr. Raddick is the bad guy here, that he is trying to do something that's unethical, immoral, inequitable. And frankly, I don't see how that can be. Because here's the reality of this. In 2018, Mr. Raddick and Mr. Fleming, the decedent, made a deal. Now that deal has been held to be unenforceable under the statute of frauds by Judge Newman, and in frankness, we think that's an incorrect ruling based on the law, but we're not going to ask the court for do-overs on every ruling that Judge Newman has made previously, because we've been down this road many times on numerous dispositive motions, and all the issues that are being raised today are issues that have by and large been previously raised and previously been resolved, and we just want to get this case tried. So we don't want to sit here and rehash the same arguments over and over and over again. We don't think that's proper, and I don't think the court wants to redo the entire case today. But Mr. Raddick and Mr. Fleming made a deal. And under that deal, Mr. Raddick ended up providing millions of dollars to Michael P. Fleming and MPFA. There's no dispute about that. There's no ifs, ands, or but about that. That happened. And he provided other assistance. Now, under the deal, Mr. Raddick's firm and Mr. Fleming's firms were supposed to be merged. That was not finalized because of tax considerations that Mr. Fleming raised. But in all other respects, everybody performed as though it had happened. Mr. Raddick kept providing funding to the firm, assistance to the firm, rent-free space to the firm, and so on. Now, it's a tragedy that Mr. Fleming passed away unexpectedly. And by the way, Mr. Raddick and Mr. Fleming and his family, longtime close family friends. So when Mr. Fleming passed away, Mr. Raddick and Mrs. Fleming worked together to try to deal with the fallout personally to Mrs. Fleming of Mr. Fleming's unexpected passing. And then it came time to figure out what to do with the firm. And there were ongoing discussions between Mr. Raddick and Mrs. Fleming about how they could handle the firm, how to keep it carrying on the firm, and to repay Mr. Raddick the north of $2 million that he had provided the firm. While those discussions were ongoing, and by the way, Mr. Raddick pledged to the extent there was any need for additional funding, to provide that additional funding to keep the firm going so that everybody could be paid and he could be repaid. But at the time, I believe, and Mr. Nicomoff can correct me if I'm wrong, the firm actually had the money to make its payroll. It wasn't about to collapse. The firm had the money to make its payroll at the time. While these discussions were ongoing, Mrs. Fleming, and again, there's no dispute about this, Mrs. Fleming went and created a new law firm. And into this new law firm, and this without telling Mr. Raddick, into this new law firm were transferred all of the assets of MPFA, every single asset. Its website was redirected to Fleming Law. The phone numbers were transferred to Fleming Law. The clients were transferred to Fleming Law. The case files, the software, everything was transferred into Fleming Law. And the argument is that this was a necessity, that it had to be done because the firm was quote unquote insolvent, couldn't make payroll, and there was some sort of ethical obligation to fleece the firm and put all the clients and assets outside the reach of the largest creditor, that being Mr. Raddick. And that's just not the case, and we can discuss why that's not the case as well. But here's what happened. All of the attorneys from Fleming Law or MPFA went to Fleming Law. And once there, they engaged in the same business that MPFA had been engaged in, which is largely a referral shop. Now, there's been zero explanation as to why exactly cases needed to be transferred from MPFA to Fleming Law so that they could then be referred on and Fleming Law could collect the referral fees. MPFA was just as capable of doing that as Fleming Law. There's also been this allegation that the rules of ethics require that transfer. That's simply not the case. And again, Mr. Nicomoff can speak to that. But on the equities, this idea that Mr. Raddick is this dastardly villain who's been trying to rake the Fleming family over the coals is not supported by the facts. And as to the motions today, they are rehashing motions that have been brought before and denied before. As to the clarity of the claims that Mr. Raddick asserts, we had an hours-long hearing on special exceptions months and months and months ago. We went claim by claim and paragraph by paragraph through our petition. On some, the judge agreed that there was a need for clarification. On others, the judge disagreed that there was a need for clarification. On those that required clarification, we clarified. And not a peep was raised about it from then until today. As to these no evidence in traditional summary judgment issues, they've been raised before and they've been denied before. And Mr. Nicomoff can now explain to the court why that is.
Thank you, Mr. Barunda. Mr. Nicomoff.
You're muted, Seth.
Rookie mistake. Your Honor, if I may share screen.
You may proceed.
Your Honor, Mr. Greenlee said that the prior notice, that the prior no evidence motion was delayed for 5 months, so we could continue additional discovery, and that, and that basically nothing came of it. Your Honor, that's not correct. If you look at this order that was entered by Judge Newman on September 29, 2022, our motion for continuance so we could gather more evidence was denied. And Judge Newman ruled against all the defendants on their no evidence and traditional motions for summary judgment. And those motions, Your Honor will note, are identical in every respect, save and except for the fact that they're made singly now instead of collectively. So I want, Your Honor needs to know that there's not one issue before the court that has not already been ruled on by Judge Newman. Your Honor, I would also point out that in the reply, it was raised that somehow Judge Newman had entered an order saying that my client was entitled to no damages because the Judge Newman had entered summary judgment saying that none of the attorney's fees were answerable to his claim. That was the subject of a motion for reclarification on March 7, 2022, a year ago. Judge Newman stated on the record that there was no such order entered saying that our clients were precluded from recovery of damages against attorney's fees. He stated that on a record. He said, if you want to know what my ruling was, look at the order that was entered. And that order was and I can go to that order that was entered on February 7, 2022. That order I'll share with you separately here. That order said, here's their summary judgment on partial summary judgment on breach of contract, says the breach of contract claim is denied to recover a division of attorney's fees on MPFA client cases. What this case is about is nothing new. This is, if your court, your honor will, we've cited three cases: the Maggio case, the Bader case, and the Arison case. Those three cases all relate to the unfinished business doctrine. Basically, under the unfinished business doctrine, when you have contingency cases that are taken from one firm to the other, either upon the death of a partner, dissolution of a firm, or malfeasance by a associate who takes the cases and runs to the other firm. In those scenarios, the old firm, dissolved firm, or widow, as it may be, is entitled to a share of the contingency fees earned on those cases when those cases are later finished. If you look here on a share screen again, Your Honor, if you look at this answer to interrogatory, this is Exhibit G to our response. Your Honor will see that $1.786 million was earned on cases, on contingency fees that were unfinished and transferred from MPFA to Fleming Law. This is not, we're not arguing new stuff. We're not arguing, we're not even arguing anything that would contradict what the ethics experts have said, or even what Mr. Stanfield has said. They say, hey, they say that that clients are entitled to their own attorneys of their own choosing. They say a bunch of stuff, but the fact of the matter is you cannot take. Nobody was entitled to take the fees from MPFA for Fleming Law. It's not allowed under law. That's a fraudulent transfer per se. We've cited extensive court case law on this, including case law involving attorney's fees cases. Your Honor, the briefing is extensive. I can, if you want, I can set forth evidence on each and every claim, as we did for Judge Newman, in hours and hours upon hearings in the past. And Judge Newman considered all the evidence and has denied their summary judgments in the past. Just to give Your Honor just a preview of the evidence that Judge Newman considered in these hour-long hearings. There was the creation on July 23rd, less than 3 weeks after Mr. Fleming's death, Natalie Fleming created Fleming Law PC. Audrey Manito was the attorney who did that. That law firm was created on the contingency that an agreement between Jeremy and Natalie was not reached on the sale of MPFA's assets, or Natalie receiving a severance fee or $1 million to leave the cases at MPFA and with Raddick, or if Mr. Raddick paid her a sum of money for select cases. When those negotiations failed, Natalie decided to simply open up Fleming Law, and on August 14th, simultaneously, Audrey, Nicholas, Natalie, Audrey, and Nicholas immediately resigned and sent letters to all the clients saying, we've opened up a new law firm and you can bring your cases to us. The clients complied, including notably a case called the Colby case. The Colby case, it was a $7 million verdict, settlement per Fleming Law's website. That $7 million settlement resulted in fees to Tracy, Mr. Greenlee's law firm, and that would be Mr. Tracy. Sean Tracy collected on that. That was referred to his firm by Fleming Law. So to sort of map it out, as Mr. Brun has suggested, that basically MPFA's cases were transferred to Fleming Law merely to be transferred or referred to other counsel so that Fleming Law could pocket those referral fees. The Colby case is an absolute example of that. We moved to disqualify Sean Tracy and his firm from the case because we believe, because of the transfer of the Colby case from MPFA to Fleming Law. Judge Newman denied that motion. And we noted that in our motion to compel that Sean Tracy and the Tracy Law Firm instructed the witnesses not to answer any questions regarding the Colby Law Firm and not to answer any questions about case referrals, et cetera. So I think it can be easily conceded, it's concluded by the court based on the evidence that's presented and Mr. Nicholas Fleming's testimony that the cases went from MPFA to Fleming Law only to be referred to outside counsel, with Fleming Law collecting $1.786 million in fees from those MPFA cases without returning any of the fees to MPFA as would be required under the unfinished business doctrine. Again, Maggio, Bader, Irison are all cases regarding such unfinished business doctrine that would also basically those cases applied would say that $1.786 million should have been sent back to MPFA to pay MPFA's creditors. So if Your Honor is wondering why it was that MPFA's $1.786 million ended up at Fleming Law instead of being sent back to MPFA to pay its creditors, Natalie Fleming testified that she wasn't going to work just to pay back the debts of MPFA. Two, she said, we just simply decided to transfer all the cases because I couldn't make an agreement with Mr. Fleming as to what to do about MPFA's debts. The other.
Mr. Nicomoff, we've lost your audio.
I think we may have lost him altogether, Judge. He seems to have frozen up. If the court would like, I can step away to let him know that he's not, if he's talking, he's not talking to us.
Yeah, if you wouldn't mind, please, that'd be much appreciated.
Certainly, Judge. 1 second.
And pardon me, Your Honor, but this is Sam Palermo again for Fleming Law. My notebook had a glitch, and so I now appear as George.
Oh, no problem.
Just for clarification when it's my turn, Your Honor.
Okay, thank you.
Your Honor, Mr. Nicomoff's computer had an issue, and he is rebooting it, and he will be back with us.
Okay, no problem. We'll wait.
All right. Thank you, Judge. While we do so, I would like to clarify something with respect to Judge Newman's order regarding a division of fees, because I think it's an important point. That order is not meant to say, and it doesn't say, that Mr. Raddick cannot recover any damages from the fees generated by the cases that were originally at MPFA and transferred over to Fleming Law to be referred on. What it says and what it relates to is, in the initial pleadings, there was a breach of contract claim, and one of the remedies sought was that Mr. Raddick was entitled to a percentage of the fees from each case that was on file at the time and signed up thereafter. In essence, he was entitled individually to a share of the contingency fee. And the judge's order is, no, you don't have a right to a share of the contingency fee, but it wasn't, you don't have a right to any damages. That's not what the order was intended to convey, and it's not what it says. And I think that's an important point. I also want to point out to the court, while Mr. Nicomoff is resolving his technical issues,
Sure.
that we've been talking for some reason about Audrey Bonito's deposition. It's not in evidence. Nobody has presented it to the court. I think it's improper to talk about it. We did not receive that deposition until after our response deadline. So nobody has filed it. Nobody has put it in evidence, and any argument based on it should be disregarded entirely because it's improper.
You stated Audrey Bonito's, is that who you just mentioned?
Yes, Your
Deposition's not on file?
Correct, Judge.
And Do we have an explanation as to that, why that's not filed? Mr.
Yes,
Greenlee?
Judge. Yes, Your Honor. The deposition is not on file because the transcript was not received by the parties until after the motions for summary judgment were filed and after the response deadline for plaintiffs to respond to the motions for summary judgment. So the timing didn't work out, and it's not on file because of that.
Mr. Greenlee?
Yes, Your Honor. I mean, that was sort of my point, is that they didn't use her deposition in their response. So, I mean, that's the only point I was making.
Has opposing counsel received their deposition, a copy?
Yeah, everybody has it.
It's just not on file with the court.
Right.
Right. And again, Judge, we didn't use it because we had to file our response before the transcript was available.
Okay, I understand.
If I may reach out to Mr. Nicomoff again and
Yeah.
see where we stand.
He's actually in the waiting room.
Oh, okay. All right, Seth, if you can hear me, I just clarified to the court a few points regarding Judge Newman's order regarding the division of fees. And I also brought up the fact that the reason we don't have Audrey Manito's deposition on file, or anybody has it on file, is because we simply didn't have the transcript before the deadline to respond to the motions.
Correct. I'm beyond rookie mistake at this point. My computer literally blew up. I have no clue what's going on, but I'm on my iPad now. My apologies to the court.
No problem. You may proceed, Mr. Nicomoff.
Your Honor, well, the reality here is that we have produced enough evidence to get past. Well, Judge Newman was not reticent about granting summary judgment when he felt like we had not met our evidentiary burdens, and he did so on the breach of contract claim, the life insurance claim, and he did feel like we met our summary judgment burdens on all of the motions that are now before the court that are effectively being reurged for the umpteenth time. There's not at this point, Your Honor, I don't know that, I urge you to read the briefs. I think there's overwhelming summary judgment evidence of the existence of a debt, B, the transfer of the assets of Fleming Law from MPFA to Fleming Law. That would be, of course, the right to collect the fees from the contingency cases. So we've established, we have established the debt, the transfer, and we've also established the complicity of each and every defendant with respect to same. Nicholas Fleming, well, their summary judgments aren't before the court with respect to reurging, but Nicholas, Audrey, and Natalie they all got together. Natalie told them all that the cases had to be transferred because the law firm was insolvent, which is one of the elements that we would need for our fraudulent transfer. They said that the law firm's insolvent, so we have to transfer the cases. And so they did. And they didn't put anything back to MPFA. So, I've done a poor job arguing on account of technical difficulties, and I don't want to waste the court's time by rehashing everything over and over again. But
you didn't do a poor job. Don't. I do have one. Can you flesh out just a bit more on the unfinished business doctrine, the liability of the employees?
Yeah, it's interesting. So the Maggio Gonzalez case was a scenario where two lawyers got married, started a law firm together, and it ended in divorce. And so they had contingency cases. And so part of the property division in the Maggio case was they both retained interest in each other's contingency cases that were unfinished, regardless of who worked on the case. And that was application of the unfinished business doctrine. So that would be an example of a dissolved or splitting law firm where the fee was an asset to be divided amongst the splitting partners. And then in the Arison case, that case where an associate, I call it the Arison case because the name of the associate in that case was Arison. Arison left one firm for a new firm, and he contacted the contingency client and said, hey, come over to the new firm with me. The old firm asserted that it was entitled to the contingency fee for this, entitled to a contingency fee based on the sum that, a portion of the contingency fee. And the appellate court sustained that and said, yes, you're right, you are entitled to a portion of that contingency fee that was earned by, that was earned because the case was originally with you and was sent to a new firm. And then in the Bader case, this was an interesting one. In that case, a widow passed, and I'm sorry, a law firm partner passed, and the partners tried to take all the contingency fees that were unearned on the unfinished business. And the widow, the court held that the widow was actually entitled to a retention of what her deceased spouse's share of that fee would be, despite the fact that she did not work on the cases because she wasn't a lawyer. And so that would be instructive as well, because that's kind of actually in weird ways very opposite of this one. But not, in other ways not, because Natalie Fleming, so when you think about MPFA, Your Honor, there were approximately 200 cases in MPFA that were transferred to Fleming law. Of those 200 cases, Natalie Fleming worked on approximately 17 to 18, and the rest of them were worked on by Nicholas and by Audrey Manito. I think Audrey said she had roughly 80, but that's not in evidence. I'm just giving the court background because her transcript wasn't ready for, wasn't available. But it is in evidence that Natalie had 17 to 18 cases that were transferred. So for her to say that she was transferring the cases for the benefit of her clients is kind of, maybe for those 17 or 18, but what about the other, roughly 175 or so? But then the next point, then the next thing I would say is that Natalie was only at Fleming law for a month before she decided to leave a Fleming law, and she went back and since she stopped practicing law in order to continue acting, I think, as a traveling judge at that point. But she was not at Fleming law or working on those cases after a month there. So it's interesting because if you apply Bader and Arison and Maggio to the facts at hand under the unfinished business doctrine, I think Your Honor would, it's absolutely conclusive that that MPFA would have been entitled to a share of the fees that were earned while at Fleming law. And one last thing, Your Honor, I can't tell you what percentage of fees were, what the split between Fleming law and MPFA would be, because all discovery requests on those issues has been refused. And we moved to compel that, and the judge sustained their objections to all that evidence and testimony. So, for their, I don't know why they did that. But they refused to allow any evidence whatsoever on what Fleming law's contribution would have been to earning of those $1.786 million in fees. So, the evidence before the court is that $1.786 million in fees were earned off the MPFA cases and never returned to MPFA. What percentage of Fleming law, what work they did on the cases, that's not in evidence. The only thing we have is Nicholas Fleming's testimony that after Natalie left, Audrey left a year later, and that Nicholas Fleming at the time of his deposition was effectively running Fleming law as a referral shop. Since that deposition, and this is not in evidence, but Mr. Palermo and Harry Fleming joined Fleming law. So, I don't really know what to say about that, but that's. I hope I meandered, so I didn't answer. But I believe I answered your question.
Yes, you did. Thank you.
May I respond, Your Honor?
Mr. Greenlee?
Yes, ma'am.
Yes.
Uh,
Yes, please.
I would just like to remind you, Your Honor, that this motion is on behalf of Natalie Fleming and Audrey Manito, not Fleming Law or Michael P. Fleming and Associates. And I just want to point out the defendants have been upfront in the discovery responses about the fees that have been collected and where they're at. That's the interrogatory answer that they shared screen with you. We've been upfront. The defendants have been upfront globally with the fees that have been collected. Judge Newman sustained an objection to discovery on individual cases, and it, you know, they say they're not trying to disturb the old rulings, but it kind of sounds like what they're doing. And I'd like to point out there's a huge hole in their evidence, Your Honor. Mr. Raddick testified in his deposition at pages 181 to 182 that he agreed that this firm, the cases they took in were low value car wreck cases. He agreed that he had no idea what the duties were that the attorneys owed to the clients, or what the value of the cases were, as far as the prospect of referring them out for a fee. You know, it's attorneys aren't jumping at the door to try to get low value car wreck cases. Nobody is. And this hole in their evidence was pointed out back in September, the same day as the hearing. Judge Newman extended their expert deadlines so they could designate competing experts. He threw them a life vest, and they've tossed it back in the ocean. You know, we're here 5 months later, and they still don't have any evidence, competent summary judgment evidence of the to contradict Mr. Stanfield or Professor Baker. And so, you know, if the court believes their argument about, okay, Fleming Law still has fees that came from MPFA, those parties are still in the case. That's not what these motions are for. This is for Audrey Manito and Natalie Fleming. And I'll stop there. If there's issues about her duties as executrix of the estate, I'll let Mr. Ditta chime in. But that's all I have here.
If I may, Your Honor, I'd like just to briefly respond. As far as the expert deadlines being extended, I objected in my summary, in that September 2022 summary judgment exchange. I objected to their late designation of experts, and in response, Judge Newman gave them additional time to designate experts. I timely noticed I timely identified and designated a rebuttal expert, Richard Wilson, and they scheduled his deposition but never moved forward with it. And that was my first point. The second point is that it is wholly compatible. First off, Judge Baker says that that under Rule 101, you can, well, what she says in Rule 101, basically competent counsel. One, Your Honor is as much of an expert on Rule 101 as all of us are as officers and lawyers, officers of the court and lawyers. And 101 doesn't say that competent counsel requirement means that cases have to be referred elsewhere. What it means is it says, make sure you're competent counsel. Now, Natalie is somehow saying that extends from beyond her 17, 18 clients while at Fleming Law to all the clients there. And that's the first point. The second point is that Rule 101 says nothing about fees. That's the unfinished business doctrine, which is separate and distinct. In fact, I believe it's in Bader where they say that a client's right to counsel their choosing fully complies, absolutely complies with the unfinished business doctrine, because a client doesn't care how the fees are split. The client only cares about being represented. And so that's really that's squarely addressed in the unfinished business doctrine, which is the sharing of fees between the old new firms, dissolved firms, what have you, is wholly and absolutely compatible with a client's right to choose counsel. So, if in fact Baker is absolutely on point and all fours that, hey, there was no competent counsel at MPFA, which, Judge, I got to tell you, we absolutely strongly dispute, because the reason why there was the reason why Natalie, Audrey, and Nicholas left MPFA was because they decided to leave. They were offered, the testimony from Jeremy Raddick was that they were offered continued salaries to remain there. Jeremy Raddick offered to continue funding that law firm. Jeremy Raddick, the testimony is undisputed that the MPFA's continued existence was not in doubt, and in fact, an attorney remained there afterwards. Marco Trevino remained there afterwards. So this idea that there was that MPFA was incompetent is just wholly unfounded. It's a conclusion without the evidentiary basis. The evidentiary facts is they still had attorneys there, and the only reason it ever became incompetent or not competent, if at all, which we dispute, would be because they decided to leave and take the cases to Fleming Law. So you can't forget the cause when you're talking about the effect. They made it, if at all. By leaving the firm, they created the circumstances of which they say justified what they did, which again we dispute was ever justified. And the last thing is that, as far as Mr. Raddick saying that he wasn't personally entitled to fees, etc., that's wholly out of context. In fact, one of the reasons why Judge Newman sustained their breach of contract claim was because Judge Newman basically said, well, I guess if Jeremy Raddick's purchase of half of MPFA was never consummated, then you can't, he said, then Jeremy Raddick can't say that he's an attorney on those cases. That was what that deposition testimony in Judge Newman's ruling was about, was whether or not Jeremy was an owner of the firm and therefore as an attorney entitled to fees from the firm, not whether or not the firm, the contingency cases and the fees they generated would have been assets of the debtor estate of MPFA and decedent Michael Fleming. I don't know if I don't have anything,
Thank you.
Yeah.
Okay. Mr. Palermo, would you like to proceed on matters before Natalie Fleming as executor?
Yes, with respect to Fleming Law, Your Honor, thank you. Judge, if I may use a tennis analogy, with respect to the motion for summary judgment filed on behalf of Fleming Law on November 2nd of 2022, I have experienced one forced error and one unforced error. The forced error is that my motion focused more on the affirmative defense to Fleming Law as a transferee under the Texas Uniform Fraudulent Transfer Act, as opposed to where in the heck is the evidence of fraud. Now, the unforced error was that due to an illness before the prior scheduled oral hearing on the motion for summary judgment on behalf of Fleming Law was heard, I wasn't able to get my reply to the defendant's response in before the court the day before the scheduled hearing denied the motion for summary judgment. So I would ask for the court's indulgence to listen to my argument, not necessarily, even though it's under the, I guess, technically a motion for reconsideration because there has been a denial of the motion for summary judgment, but the arguments that I made in the reply, in the motion for consideration were the arguments that I intended to make in the reply to their response. And as the court will see, there is no evidence of fraud. It's all conclusory statements, and it reads like a lawyer's pleading. And I will get into that in detail if the court will please indulge me. I think you're going to see, Judge, what really happened here is that Jeremy Raddick found himself in the position as an unsecured creditor of the Michael P. Fleming and Associates law firm. That's what the undisputed facts do show. He did. He was not a member of that firm, although he tried to argue that. And he says in his affidavit in a conclusory way, I believed I was a stakeholder. Well, what you believe is not competent summary judgment evidence. Okay, and you will see his declaration is replete with these kind of conclusory statements, which do not establish fraud, at least not in the United States, maybe in Russia, maybe in China, but not in the United States of America. This is not a court of equity. He was an unsecured creditor, just like the landlord, just like the cable company. And and I'm sorry that happened to him. But just because it happened to him, you don't just get to sue everybody for everything, like he's suing the individual members of the law firm, like he tried to assert a cause of action for the life insurance policy that Michael P. Fleming, that Michael Fleming individually paid out of his money for his widow and his family in the event of his death. And you know that the record in this case will show that Jeremy Raddick sued her for that life insurance money and testified, well, I just thought all life insurance was key man insurance. He could have taken out key man insurance on Michael's life. He didn't. He was not a partner. He was ready just to rock along. And this is not a court of equity. This is a court of law. So let's just examine what the law is and what the facts show. The defendant's position is this has already been denied by Judge Newman. Well, I can't speak for prior counsel's representation of Fleming law. I will say this. The record will show that prior counsel at one time represented Harry Fleming, who had a defense under the attorney immunity. And a motion for summary judgment was filed by another law firm, and that motion was denied. And Judge Newman gave me an opportunity to have that motion reconsidered, where I pointed out to him that there is no way that Harry Fleming, who was a lawyer and provided legal advice, can be sued in this case. It's just the program that they followed. Let's just sue everybody for anything we can think of, and let's see if we can shake some money loose, because we are an unsecured creditor and we really don't have a cause of action under any Texas law, and not the facts. So let me say this, Judge. Just like there can be no charge for accessory to murder without a murder, there can be no cause of action for the Texas Uniform Fraudulent Transfer Act without a fraudulent transfer. And the purpose of the act is to prevent fraudulent transfer of property or debtors who intend. They have to prove intent, Judge. They don't even get close to it. They have some there's some lawyer argument, but they don't have any competent evidence, not anywhere. So they have to prove that there was an intent to defraud the creditors by placing the assets beyond the reach of the creditors. And there are a couple cases that I didn't cite in the motion for reconsideration, and that with respect to the element of intent. It's the Maglita case. If I'm saying that correctly, it's at 130 Southwest 3rd, 397, and the Connell case at 889 Southwest 2nd, 534. So the question for the court to focus on, respectively, Your Honor, I submit, is where is the evidence of fraud? keep that in mind as we go through the summary judgment evidence that we brought and what this wholly conclusory declaration of Jeremy Raddick shows, because there is none. It's all conclusory, no competent evidence to defeat a summary judgment, and it's nothing more than what you would see in a legal pleading, which of course we know a legal pleading is not summary judgment evidence. I'm not going to go over the facts as we found ourselves here, Your Honor, but I will say this. They would have the court, Michael Fleming was the sole shareholder in Michael P. Fleming Associates. That was it. It was him. Just like when I worked for John O'Quinn PC. John O'Quinn was a sole shareholder of John O'Quinn. That law firm, it could not continue to exist as John O'Quinn PC because he, as a sole shareholder, was deceased. It's not like these like Nicholas and Audrey were, and Natalie for that matter, were partners in Michael P. Fleming Associates, and they somehow started a new firm and just dissolved that partnership. No, that partnership, that was not a partnership. It was a sole proprietorship that had to be dissolved. And so what did they do? They did what had to be done under the State Bar ethical rules and under guidance by State Bar Counsel, and as shown by the expert witness affidavit. They contacted the clients and said, this law firm no longer exists because the sole shareholder is dead. So you need representation. We're going to follow our responsibilities. Natalie said, I'll follow my responsibilities as the executor of the estate of Michael to show that there are options for these clients. They can find a whole new lawyer anywhere they want in the United States of America, or they can continue with lawyers that at one time were employees of Michael P. Fleming and Associates. And some did that. Some continued, some did that by way of becoming clients of Fleming Law. And the fact that Natalie incorporated Fleming Law is not relevant to anything at all, but no issue at all before this court. And so what happened? Fleming Law, in the ordinary course of their business, said, we will accept the representation of these clients in the course of our business. We will provide competent legal representation. And they even went a step further and said, and if we can recoup expenses related to the cases for these clients, we will reimburse Michael P. Fleming's estate for those expenses. And that has been done, Your Honor, as demonstrated by the affidavit by Nicholas Fleming. That's part of our motion for summary judgment and is not disputed. So the defendants cite all kinds of cases on fraudulent transfer, but what they can't provide the court is one single case in where a law firm accepted clients from a sole proprietorship that had to be shut down because of the death of the sole proprietor. And now a creditor of that prior firm can somehow come and take fees away from that lawyer. They can't cite one case because it doesn't exist. It's absurd. Respectfully, Your Honor, if you had a law firm and you were approached by a client who said, Madam lawyer, I was a client of this other law firm, but the sole proprietor of that law firm has passed away and I need representation. Would you agree to represent me? And if you said yes, do you think there's any way that you could imagine that you would be in legal jeopardy to be sued for having worked that case and worked that case successfully and made money, that you could be sued by a creditor of the prior law firm? No. That's why they can't produce such a case. It's nonsensical. It's an absurd argument. They're trying to take you into la-la land to get you off focus of the real facts of this case. Yes, Yes, we don't deny that he infused money into that law firm, but it doesn't mean that he can recover money just because he did. Now, let's look at what constitutes competent evidence to defeat a summary judgment. And by the way, and by the way, for the record, we are objecting to the declaration of Jeremy Raddick, and I will show you and go through with you the parts of the declaration that are conclusory on its face under Texas law. But even unobjected conclusory statements do not raise a fact issue. Statements like "I believe," like "to the best of my knowledge," courts have said are never to be used to support or defeat a summary judgment. Statements like "to the best of my knowledge," no, courts that is summary judgment evidence law 101. The courts have held that is no evidence at all. And I cite the court, as I did in my briefs, the Campbell versus Fort Worth case, 705 Southwest 2nd 400. And as the court stated in the Robert versus Davis case at 160 Southwest 3rd 256, if the court were to allow that kind of evidence as summary judgment proof, a person could testify with impunity. Here's what the court said: if you were to allow this, a person could testify with impunity that, to the best of my knowledge, there's 25 hours to a day, 8 days a week, and 13 months to a year. That is conclusory statement and is not summary judgment evidence proof at all. A conclusory statement is one that does not provide underlying facts. It just provides objective opinions, which is what has occurred in this declaration under the salient points that they try to fashion in to some kind of argument that supports this fraudulent transfer allegation. So let's closely examine the declaration of Jeremy Raddick, Your Honor, and let me share my screen for a second. So, Your Honor, paragraphs 1 through, I'm sorry, paragraph 1 is just him is introductory to Mr. Raddick, but paragraphs 2 through 5, Your Honor, are simply stating what we do not dispute, that he invested money in Michael P. Fleming and Associates. Again, has nothing to do with Fleming law, but he did do that. But respectfully, all that shows is that it proves he's an unsecured creditor, and we don't dispute that either. But just like the cable company and the landlord can't come sue Fleming law, or Natalie Fleming for that matter, even though I don't represent her, just like the cable company can't file a lawsuit to do that, they don't have standing to do that either. Not only do they not have standing, they have no proof. And let's look at his declaration in paragraph 6. Believing that I was part of Michael P. Fleming and Associates. Well, as I just went over with you, Your Honor, the case law is clear. Believing is not competent summary judgment. It's not. You can't consider it. It is no evidence at all. Let's look at statements in 7, 8, and 9. Decedent often told me, decedent told me, decedent told me. Well, Your Honor, Rule 601, I guess, they want to ignore the rules of evidence in this case, and clearly that's what they would have the court do also. That's the dead man statute. This is not evidence. This is stricken under the dead man statute. if for good reason. You can't just say a dead man told me this and a dead man told me that. You have to have corroborating evidence. They have not produced any, so it can't be used at all. And by the way, but more directly to my client Fleming Law, it has nothing to do with their assertion against Fleming Law. And they talk about the decedent shared with me that the Colby case. Well, again, it has nothing to do with Fleming Law, but they would have the court to believe that the Colby case was like a work of art that was worth $2 million. Colby was a client, Judge. Colby was a client which could have turned into no money at all. That case, look, I've been doing personal injury cases since 1983. And a lot of cases that you think are great turn out to be just a sinkhole of money. And I guarantee you, if that happened with the Colby case, Mr. Raddick wouldn't want to be sued for the expenses incurred as a result of that. But it was not a piece of art. It was a client. Paragraph 10 has nothing to do with Fleming Law. Paragraph 11, nothing to do with Fleming Law, but paragraph 12 and 13 do have something to do with Fleming Law. Let's take a look at this closely, Your Honor. He says, Natalie's incorporating Fleming Law and transfer of MPA's business, website, phone lines, case files, client, furniture, computers, staff, attorneys, etc., to Fleming Law came as a complete surprise to me. Okay, first of all, Your Honor, there was not a transfer of those things. It was a sale. And as you will see from Natalie Fleming's deposition that was attached as an exhibit to our motion for summary judgment, the furniture was sold, page 22 of her deposition. Computers sold, page 123 of the deposition. The website was not owned. The undisputed evidence shows the website was not owned by Michael P. Fleming, PC. That's at page 193 and 194 of her deposition. Let's go further into his statement. It never occurred to me at all, again, conclusory statement. What occurs to him or doesn't occur to him, that's not fact, okay? It could never occur to him that it's going to snow sometimes in Houston in December. Okay, but that doesn't mean that it doesn't occur and can't be a fact. So he says, it never occurred to me that they could simply transfer it into a new entity. It wasn't a transfer. Again, Michael Fleming was the sole proprietor, sole owner of Michael P. Fleming Associates. This wasn't a transfer of that business. This was a sale of assets in that business. In the next sentence, it never occurred to me, not competent summary judgment evidence under Texas law. But he says, it was never occurred to me that someone could decide that the financial assistance that I provided in PFA would simply be avoided, and the fruits of my and decedent's efforts with Michael P. Fleming and Associates would be collected by Fleming Law, Natalie, Nicholas, Audrey, and others without any attempts to return to MPA the profits that had been earned through MPFA's efforts. Your Honor, what efforts did he supply? Yes, he put money into that law firm. What efforts did Jeremy Raddick provide that turned that Colby client's cause of action into money? Nothing, a big zero. So why it never occurred to him, I can't answer to that, Your Honor. I can only say under Texas law, that is not competent summary judgment evidence. Let's go to 13. This is the most bizarre thing. However, this is just what has apparently occurred and was intended. So he is going to tell the court, in his mind, what was intended. That is not competent summary judgment evidence. It might be in Russia. It might be in China. It's not in the United States and certainly not in Texas. You can't just say, in my mind, that's what somebody intended. That's not how we practice law under the rules of evidence in this country, Your Honor. And so, again, going down, he says, instead, it appears, what appears to him, Judge, again, totally conclusory statements, not competent summary judgment evidence. And Judge, why are they bringing this before you? Because that's all they have. It's all they have, and they're hoping they could blow some smoke at you and say, oh, Judge, please feel sorry for him. He put all this money in there, and and he's out all this money. Well, I'm sorry, this is not a court of equity, okay, Your Honor. This is you are a court of law, and you have to be guided by what the law is and what the evidence is, not when somebody apparently thinks somebody attended, or by what never occurs to somebody, or what it appears to somebody. That's not the proof. And with respect to the employees of Michael P. Fleming Associates becoming part of Fleming Law, and he's like, well, that was an asset. I mean, think of how bizarre that is, Judge. That's like Michael Fleming, like they were slaves, and Michael Fleming had title to them, and Fleming Law assumed that title. These were individuals that could have chosen. Nicholas Fleming could have chosen to join another law firm. Audrey could have chosen to join another law firm. George Fleming could have chosen to join another law firm. They became employees of a different law firm. It's not like they were some work of art or some chattel that became transferred to another entity. Again, it's a bizarre argument, Judge. When you blow all the smoke away and you get beyond the fact that, yes, he did invest this money, but when you get beyond that, if this was $1,000 investment, Your Honor, and you looked at all this, you would say their argument is insane. It's insane if it's $1,000 he invested. It's insane if it's $2 million, and it's insane if it's $20 million or $200 million for that matter. You still have to look at what the law is and what the summary judgment evidence is, Your Honor. So I submit, Your Honor, that what you're seeing in the declaration in paragraph 12 and 13 is what you would read in a pleading. And as we know, pleadings is not evidence. They could put in a pleading, it never occurred to plaintiff this, or this was intended by Natalie and George. They could put that in the pleading, but pleadings are not evidence, and pleadings don't control the adjudication of a case. Paragraph 15, I won't bore the court with any more time, only 14 and 15 or 16, because they refer nothing with respect to Fleming Law. Again, they just include the evidence that he did invest this money, which we do not dispute. We do not dispute, but again, it's not relevant to the issues before the court right now, Your Honor.
Thank you, Mr. Palermo. Mr. Nicomoff or Barunda, did you have anything?
Your Honor, if I may continue, because I do want to argue the affirmative defense also. And that in the unlikely, let me get back to my screen, Your Honor. In the unlikely event Can the court see me, Your Honor? Hello? Help me out here, please. Just go in now, help me out. Bear with us, Your Honor.
Thank you.
Can you see me, Your Honor?
I can see you fine.
Okay, then I'll go forward. So Judge, I do want to, I do want to represent my client fully. And I do want to argue the alternative argument. I don't think there's a real need to, Judge, but I do want to point out to the court that even if there was an intent on Natalie Fleming to defraud Jeremy Raddick out of legally defraud him out of money by doing, and again, I would ask the court this: what else could Natalie Fleming have done? What could she have done differently to take care of these clients? The answer is nothing, Your Honor. The answer is nothing. She did the right thing by advising these clients under the Texas ethical rules that they have, that the law firm is shutting down. It can't exist because Michael Fleming has deceased. He was the sole proprietor of that law firm, and there's nothing more that she could have done. So again, without rehashing what happened with respect to Fleming Law, they accepted these clients, and the case law is clear that under the Texas Uniform Transfer Act, if a transferee has taken something transferred, and again, it's really a misnomer here, Judge, because these clients weren't transferred. These clients had their own free will, and see, that's where they're trying to get you to make that big leap. Also, it's not a transfer of clients. These clients had their own free will of where to go. But even assuming it was a transfer, if the Fleming Law took those clients in good faith and provided reasonably equivalent value, then there is no then what those things cannot be avoided, even if there's a showing of fraud, which, as I have emphatically argued respectfully, that there's not. But if you look at the Janvey case, Your Honor, and it's really instructive because Janvey, and let me see if I can share my screen again. Court will indulge me. Here, help me out here to show this other document, please. So, Judge, the Janvey case is an instructive case because it involves something that most of us here in Texas are familiar with. It involves the Alan Stanford Ponzi scheme, the guy that had the big tower over there at the Galleria. And what happened was that entity ended up in receivership and had paid the Golf Channel $6 million for advertising. And the receiver in that case sued the Golf Channel to try to get that money back under the same act that the plaintiffs are suing for here, the Texas Uniform Fraudulent Transfer Act. There were cross motions for summary judgment in the federal court. The district court ruled in the Golf Channel's favor. At first, the Fifth Circuit reversed the district court and found that the Golf Channel provided zero value to the Ponzi scheme's creditors. But then the Fifth Circuit later vacated that opinion and certified a question to the Texas Supreme Court to determine what constitutes value under the Texas Uniform Fraudulent Transfer Act's good faith affirmative defense, which we have asserted here, Your Honor. And answering that question, answering the Fifth Circuit's question, the Texas Supreme Court held that reasonably equivalent value is found if, one, there was full performance under a lawful arm's length contract at fair market value. Two, consideration was provided that had objective value at the time of the transaction. And three, the exchange was made in the ordinary course of business. We have provided the affidavit of Nicholas Fleming on these issues, Your Honor, which are undisputed, because what the evidence shows is these clients came to him. He accepted representation in the ordinary course of his business. He provided legal representation and that had objective value, and it was performed at arm's length. Now, the court went on to say that it's not necessary that the consideration provided preserve the estate of the debtors. But Nicholas, the Fleming law actually did that. They did that step, not even required by Texas law to defeat a cause of action under the Texas Fraudulent Transfer Act, Uniform Fraudulent Transfer Act. He did that by, number one, providing competent legal representations for these clients so that it would avert any legal malpractice claims that they may otherwise have against the estate of Michael Fleming PC, and that he provided compensation to reimburse Michael P. Fleming PC for some expenses covered. So he took that extra step. So, Your Honor, I would submit that the mistake I made, again, getting back to the full circle here, my forced error was that in my motion, I focused more on the affirmative defense than I did on the real threshold issue, which is, where is the evidence of fraud? You can't, in a declaration, say, apparently this is what they intended. That will never fly. That will never pass muster in the Court of Appeals in this state or the Texas Supreme Court. Think of the, I worked for a federal judge before I became a private practicing lawyer. And when an attorney presented some argument that appeared to be a little, let's say, outside the envelope, Judge Sterling said, let's think of the real consequences if we were to accept the argument that they are making. And the real consequences would be, Judge, that anybody could submit an affidavit like Jeremy Raddick and say, well, apparently this is what they intended, and that gets them to a jury. No, not here, Judge. Not going to happen. Respectfully, it should not happen here. This motion should be granted. This cause of action should never see a jury in this case. And if it were, and there was be some kind of jury that would ignore the law, and which would be the court's charge, and ignore the rules of evidence, it would never be held up on appeal, and the Texas Supreme Court would never allow, respectfully, this to go forward because of the consequences, just the practical consequences that would occur allowing a case like this to go forward. So with that, Your Honor, I thank you for the court's indulgence. I meant to include these arguments again in a reply, and all these arguments were intended and it to be made and would have been made at the oral hearing, which was canceled at the court's discretion. But I thank you for the opportunity that we were here today, and the court gave me the opportunity to adequately present the arguments and what the facts show and what Texas law shows, Your Honor.
Thank you, Mr. Palermo. Mr. Nicomoff or Barunda, did you have anything you wish to add or respond?
I do, Your Honor, but I certainly don't want to step on Mr. Barunda. Mr. Barunda, do you want to go first?
No, go ahead, Seth. But can we get rid of the document? I can't really see anything other than the document that's on the screen.
Yeah, I apologize. Let me get my, I'm an old dinosaur here. Let me get some IT help.
Thank you.
Your Honor, if I may just sort of jump straight in, first off, this whole idea of Mr. Palermo's conflate. Well, first off, he did not urge no evidence grounds in his motion for summary judgment that he wishes you to reconsider. The no evidence grounds were urged for the first time upon his reply to our response. So, Your Honor, I think that Your Honor should disregard all the no evidence argument that was made, and I think Your Honor should also refer back to the original order by Judge Newman denying their no evidence motion for summary judgment on these same grounds. Your Honor, all of Mr. Palermo's summary judgment evidence objections were heard and considered and not ruled on by Judge Newman, but there's nothing new here that Judge Newman hasn't already seen. Regarding this whole sole ownership of a law firm by Mr. Fleming, I think that what they're trying to do is they're trying to conflate some ethical issues there. And so basically it is true that a sole proprietorship, when the lawyer at a sole proprietorship, when he's the only lawyer there, when he dies, obviously there's nobody there to continue the representation. And there are circumstances set forth in the ethical rules for that circumstance. Here, there was a law firm that was wholly owned by Mr. Fleming, and Mr. Fleming died, and his ownership stake was then passed to Natalie Fleming, who is a lawyer, but that law firm was not a sole law firm that had 5 attorneys at the time of his death. So this whole argument about sole ownership, sole firm implicates ethical rules and ethical obligations that are not applicable here because they're easily distinguished on their face. The second thing I wanted to come at was that this, the life insurance policy, that's already been met and ruled on by Judge Newman, but I will say there's $3 million in life insurance proceeds, and those had been pledged to Mr. Raddick as Keyman Insurance. Judge Newman found that because there was no further writings on that pledge, that Mr. Raddick's claim to that was dismissed on summary judgment. We've abided by that judgment, never asked for reconsideration. As it's been now admitted by Mr. Palermo that we have an unsecured creditor, and also he's admitted that the contingency fees cases were transferred to Fleming Law without any fees returned back to outside of hourly, returned back to MPFA. Again, Your Honor, the unfinished business doctrine is wholly and absolutely applicable. The Bader case, judge in the head notes, Judge Sparling holds that contingent fees files pending at the time of death of partner and the law firm were assets of the partnership. They're assets of the firm, Your Honor. The contingency fee case files were assets of the firm, and the right to payment is absolute and still retained by MPFA. It has not been honored by Fleming Law. I don't want to keep repeating myself, but I want to keep returning back to that point that the contingent fees are the fraudulently transferred asset. That's in main contention in this case. Mr. Palermo says that there's no evidence of fraud, and he cites the Janvey case. The Janvey case, one of the first things out of the gate in Janvey case is that there has to be innocence, an innocent third party. There is no innocent third party because Nicholas Fleming, who is the current owner of Fleming Law, and Natalie Fleming, who is the initial owner of the law firm, knew about, in fact, they told everybody that the MPFA was insolvent by their determination, not agreed, but that's what they say it was. And they knew, they had personal knowledge. They were insiders. And under Janvey, and under the Janvey in particular, that immediately destroys this whole, the reasonable equivalent value defense, because they can't jump past the first prong of innocence. But when you look at the second prong of the Janvey case, is that there be reasonably equivalent value. Somebody's willingness to accept fees without reimbursement to the originating firm, I don't think it counts as reasonably equivalent value under any analysis. It's that's conclusory only. And then a lot of time was spent on Mr. Raddick's affidavit. Your Honor, that's not the sole evidence before the court, but I will submit that is certainly evidence that stands on its own. But Your Honor has a lot of that deposition testimony before her. which all independently support each and every element of the causes alleged. There's also the suggestion that MPFA had to be dissolved because of Mr. Fleming. Your Honor will know that the ethical rules do not require the dissolution of a firm just because a partner or an owner dies. You have to change the name of the firm so it's not be misleading. You can certainly maintain somebody's name in a firm in memoriam. There's just no there's to say that the firm had to be dissolved because Mr. Fleming died. Just a conclusion wholly supported by the applicable ethical rules. In fact, there's just zero summary judgment evidence before the court, expert otherwise, that they decided to close the MPFA down because Michael Fleming died. In fact, the summary judgment evidence before the court is they moved the cases over and they left MPFA because they decided it was insolvent and because they didn't want to have to pay the debts owed to Mr. Raddick, and the business solutions that Mr. Raddick offered as far as continuation of law firm, negotiated payments, negotiated purchases, all these business negotiations fell through. So they decided just to take the cases without compensation of the fees back to MPFA. They just left with the cases because they didn't get an offer that Natalie wanted. And then, Your Honor, as to fraudulent intent, the writers of the Texas Business and Commerce Code, in their wisdom, did not say that there has to be evidence upon summary judgment or even a trial of fraud. There has to be. They actually give a list of circumstances giving rise to conclusion of fraudulent intent, and there's a list of 10 factors. I'm not going to go through it with you because my computer remains inert and I don't have all 10 of them in front of me, but we listed them in our motion, and we've also identified summary judgment facts meeting most, if not all, of those circumstances. Concealment would be one, knowledge of insolvency would be another, intent to remove the assets from being answering to a creditor's debts another. As far as the concealment goes, Your Honor, honestly, if defendants don't want to produce evidence of what work they put into the cases, et cetera, if they don't want to produce that evidence, we moved to compel. It was denied. Okay, fine. It's really their burden to sit there and tell you how much value Fleming Law put into the MPFA cases such that they're entitled, what share of the MPFA fees they earned and what share should be returned back to MPFA. They decided not to present any evidence during discovery of that. They don't have an expert designated on that. It's their strategy. I'm not, I don't, it's an honest strategy. It's they're flat out that, they said they're not going to present evidence of that. So I'm not saying that they're being dishonest in refusing to provide us evidence the same, but nonetheless, it is concealment. That to this day, there's absolutely zero response to all of our requests about any of this, about the fees that would have been earned at Fleming Law versus MPFA. They just didn't want to participate in discovery without respect, and that's fine. That's their decision. But there was concealment because from February 23rd to August 14th, not a word was said to Jeremy as the preparations for the departure of the MPFA associates in the files was plotted and while they prepared. And then on August 14th, they pulled the trigger without notice to anybody. That simply, in the dead of night, moved everything over with a simultaneous letters to clients and a resignation. So, that was the choice they made. And that, in fact, squares fully with fraudulent transfer to avoid answering the debts. And I think, as far as any suggestion that none of these folks had anything to do with it, look to the other guy, not look at me. We have alleged conspiracy. We have alleged alter ego. We have alleged breach of fiduciary duty to creditors during a zone of insolvency. So we have a lot of causes out there that have been alleged that not all have been addressed by argument today because everybody chose to focus on fraudulent transfer. But For the same reasons that Judge Newman found fit to deny on multiple occasions the summary judgments that have been urged and re-urged, Your Honor should do so today, and we deserve a trial on these issues. Thank you.
Thank you. Mr. Ditta, do you have anything you wish to add on either of these two motions? Well, one to reconsider.
Your Honor, if I just may add a little bit to what Mr. Greenlee said, and this is on behalf of Natalie Fleming as independent executor of the estate. Anything that is alleged that Natalie may have done a month after her husband passed away in the creation of the Fleming law, all of that, if it was done prior to Natalie Fleming even being appointed and qualifying as independent executor of the estate. So I think the significance of that is that she can't be held liable as independent executor for having done these things when she wasn't even appointed at that time. So I just think when you're considering these motions that you take that into account with respect to Natalie Fleming in her capacity as executor, to the extent they're arguing that she has somehow done something wrong with respect to Mr. Raddick in her capacity as executor. And that's all I have, Your Honor.
Thank you.
Your Honor, just brief response to Mr. Ditta.
Yes, thank you.
I'll be very brief. Mr. Ditta is correct. The events of the initial transfers is August 14th. And Natalie was appointed on August 20th. However, a lot of their defenses, including the expert testimony of Mr. Stanfield, is that she took these steps, including Ms. Baker, too, I think also says the same, that all these steps were taken in her capacity as executor. And, it's a little, if you want to say that she didn't do any of these as in her capacity as executor, then I think their summary judgment evidence presented to the court in the form of expert testimony needs to say that. Instead, it says that she did these for the benefit of the estate, the business judgment as executrix for the benefit of the estate, on and on. And I do apologize because I have focused on the date on the events of August 14th. However, there's summary judgment evidence that's before the court, and I can specifically identify if the court wants further briefing about events occurring after August 14th. But George Fleming stayed according to his deposition testimony, he remained an employee of MPFA for almost a year afterwards, and then the same breath he was, I think Nicholas Fleming testified that George Fleming was at Fleming Law. So there's confusion there as to how to separate the conduct of the individuals with respect to what they did for the estate and what was done for the Fleming Law and MPFA. One last point is I think if Your Honor needed further on this, I'm happy to go back through it, the summary judgment facts, and identify events that occurred subsequent to August 20th. I can do that, but again, Your Honor, I think it kind of, Mr. Ditta is right. We're complaining of many of the events that occurred prior to her being appointed. However, their defense that she did that everything she did was to benefit the estate, as executrix, at least with respect to some of their expert testimony, I think very much undercuts what Mr. Ditta said. So if they wanted to further discriminate between the events as individually and versus executrix, we'd be happy to sort of address that. But to this point, it's been more jumbled from the defense than from the plaintiff.
Thank you.
Your Honor, may I have a 60-second rebuttal, Your Honor, to counsel's argument?
Mr. Palermo? Yes, go ahead.
60 seconds. Thank you, Your Honor.
Okay.
Your Honor, again, going back to what I learned for Judge Sterling as a law clerk, the consequences, when you think of the consequences, and coupled with the fact that they can't cite a single case where a law firm as a transferee has been sued under the Texas Uniform Fraudulent Transfer Act, there's a reason for that. The floodgates would open. If the court were to allow this case to go to trial on that conclusory affidavit by Jeremy Raddick, and that is their evidence. And by the way, it doesn't matter that we didn't plead this as a no evidence cause of summary judgment or traditional. You still have to look at what the evidence is. And if the court were to allow a case to go to trial on that conclusory assertions made by Jeremy Raddick, the floodgates will open. If Law 360 gets a look at this article and says this is all it takes to get a subsequent law firm to trial in Texas, I guarantee you the courts are going to be flooded with cases, and I would submit improperly so, and that's why they can't find a single case, Your Honor, and they never will.
Okay, thank you so much. We do have a motion to compel regarding Harry Fleming as a former party, needing his name to be removed off of the title in references to Harry Fleming.
Yes, Your Honor. Thank you for reminding me of that. Yes, because it is public record, and he has been out of the case for some time now. They continue to have his name in the style. They continue to have allegations against him, in the pleadings and, in Jeremy Raddick's declaration. But that's not proper, Your Honor. He's been out of this case now for several months, and we had asked the court to grant that motion also.
Mr. Nicomoff, Mr. Brunda.
Your Honor, if I may just briefly, I can briefly respond. So I think in making this argument, Ms. Palermo misunderstands the difference between a summary judgment order and a final judgment. A final judgment would be something that was final and not appealable any further. In that event, I guess it could be improper for us to be, continuing to sue him in the face of a final judgment that was final, 30 days after a trial and without an appeal. However, there's an order, and I think we briefed to the court the distinction between an order and a judgment, and there is no judgment before the court on Mr. Harry Fleming. There is only a order that is not final. It's interlocutory. It's an interlocutory order, not a final judgment. So you can't tell some. Well, if there are steps that Mr. Palermo could take, he could ask the court to sever or separate or do all sorts of things. None of that's been taken. You can't. The relief he's requested is inappropriate and unavailable unless and until there's a final judgment, and there is not. Thank you.
Thank you. Okay.
And I'll
Thank you.
make that motion orally now, Your Honor.
I'm sorry, I didn't hear you, Mr. Palermo. What did you say?
Then I would like to orally make that motion to sever now, because I would be willing to bet everybody here a steak dinner or the food of their choice that they are not going to appeal that summary judgment on attorney immunity. It will be a frivolous appeal, and they will be sanctioned.
Okay. Thank you, Mr. Palermo. I'm going to take these matters under advisement. There's a couple of things that I just wanted to reread. And thank you for your time today, and you are all excused.
Thank you, Your Honor. Your Honor, if I may, is there any additional, you heard a lot today. Is there anything you would like additional clarification on? We'd be happy to submit additional.
No, I have everything and I've read everything. There was just a couple of things I want to reread after hearing some of the testimony. Thank you. Mr. Brunda?
No, this is Scott Greenlee.
Oh, Mr. Greenlee.
I just wanted to correct the record on one thing. This was earlier, and I thought I'd get an opportunity, but Mr. Nicomoff said earlier that we were the ones that missed our expert deadline, and I just pulled up the DCO. We filed our experts designations on July 25th, 2022, which was the deadline for parties not seeking affirmative relief. So I just wanted to make that.
Thank you, Mr. Greenlee. Thank you for that clarification.
But Okay, but
Okay,
it was an
Thank you.
affirmative defense. But it's
thank
okay.
you. Thank you. Have a great afternoon.
Thank you, Judge.
As well,
Bye-bye.
Your Honor.